Welcome back. This is session 2, the role of tax incentives in the energy sector on the climate change challenges. I'm Pasquale Pistone. I'll be chairing this session, and we have three distinguished colleagues that will present their ideas together with me. As you may see from the program, the first presentation will be by Luis Cazorla Prieto from the Rey Juan Carlos University of Madrid, and Luis will be presenting on tax incentive schemes in the electricity sector. Luis, the floor is yours.
Thank you very much, Mr. Chairman. I want to express my first words to thank Marta Villar to give me the opportunity to share these moments with you. And I confess in advance that I used to speak in English in sport and parliamentary matter, but never in tax matter. So you will forgive me if I'm not so accurate as I should be. I'm going to read the paper I've prepared, but the full paper is in the organization table, and I hope it will be published later on. The object of the present paper is to provide an overview on how tax incentive schemes are crucial in view of the climate change challenges faced by the European Union. It analyzes how electricity taxes have been regulated at the European Union level and finalized with the assessment on how tax incentive schemes of different European Union member states need to be set up in compliance with European Union legislation on state aids. The European Union has set itself targets for reducing its greenhouse gas emissions progressively up to 2050. These targets are defined to put the European Union on the way to achieve the transformation towards a low-carbon economy as detailed in the 2050 low-carbon roadmap. In short words, energy taxation, when given the right incentives, plays an important role in reaching these objectives. The Council Directive of 27th October 2003, the so-called Energy Taxation Directive, widened the scope of the minimum rate system to include to all energy products, including coal and coke, natural gas and electricity. It also updated the minimum rates for mineral oils. The aim of this legislation was to reduce distortion caused by divergent national tax rates, remove competitive distortion between mineral oils and other energy products, and create incentives for energy efficiency and emission reductions. The Energy Taxation Directive provides the framework for the harmonization of energy products and electricity within the European Union. More specifically, it defines the taxable energy products, lays down the minimum rates that are to be applied to each according to their use, and set up the condition for exemption or reduction to minimum level of taxation. Tax incentive schemes and state aids. It has to be noted that the adoption of national tax incentives might hit one of the keystones of the European integration, the maintenance of the fair play level of competition within the internal market. Under the Energy Taxation Directive, tax exceptions or reductions for biofuels and electricity are allowed. Since the implementation of the optional categories of energy tax relief described in the Energy Taxation Directive depends on national political preference, that is clarified that such preferential treatment may constitute state aid. In this case, the measure normally has to be notified in order to allow the Commission to assess the compatibility of the aid scheme with the common market. No need for such notification exists, and the respective aid scheme is automatically approved to the extent that it is covered by General Block Exception Regulation. Currently, only 13 categories of energy tax incentives qualify for automatic approval under the general block exemption regulation. This is due to both the legal framework into this regulation is embedded and the condition established in this regulation itself. Under the current general block exemption regulation, fiscal aid schemes in the form of reduction in environmental taxes fulfilling the condition of Council Directive of 27th October 2003 shall be exempted from the notification requirement, provided that the conditions laid down are fulfilled. Only the following requirement must be met. First, the harmonized energy tax concern must be an environmental tax. Second, the design of the tax relief measure must ensure that its beneficiaries still pay at least the respective minimum level of taxation set by the Energy Taxation Directive. Third, demands that the beneficiaries of the tax reduction shall be selected on the basis of transparent and objective criteria. Finally, the aid shall not be granted for biofuels which are subject to a supply or blending obligation. Guidelines on environmental and energy state aid for 2014-2020. On April 2014, the European Commission adopted its new guidelines on environmental and energy state aid for 2014 to 2020. The guidelines set out the condition under which state aid in the field of environmental protection and energy can be declared compatible with the European Union internal market. The new guidelines promote a gradual move to market-based support for renewable energy and address the market distortion resulting from subsidies granted to renewable energy sources. The objectives are to foster sustainable, smart, and inclusive growth in a competitive internal market to allow the European Union to focus its enforcement on the cases with the greatest impact on the internal market to streamline the rules and provide the faster decisions. The guidelines designate limits for the design of government state national support schemes for renewables and lay down the principles that the European Commission, will apply when assessing whether state aid granted by member state is compatible with the internal market. Basically, member states are free to design the support schemes, but they must notify state aid that does not benefit from exemption or approval to the European Commission. Otherwise, such aid cannot be granted. A state aid granted without the European Commission approval is unlawful and subject to recovery with interest for 10 years. On the other hand, in the guidelines, the European Commission points out that well-designed public support measures can make a key contribution to achieving the European Union energy and climate objectives for 2020 and strengthening cross-border energy flows. On the other hand, it is also taken into account that public support measures have caused serious market distortion and increased energy costs for consumers. The guidelines aim at supporting member state efforts in reaching their 2020 climate targets, while addressing the market distortion that may result from subsidies granted to renewable energy sources. They promote a gradual move to market-based support for renewable energy, limiting state aid to what is strictly necessary. Aid in the form of reduction in or exemption from environmental taxes. Reduction in the funding of support for energy from renewables has been developed in the guidelines. These reductions are introduced to ensure that the most energy-intensive investment would not disproportionately burdened by taxes, which would cause disadvantage towards competitors that are not exposed to such taxes or charges. I say that the guidelines allow the grant of such reduction or exemption, but under the very strict condition. There is distinction made between harmonized and non-harmonized taxes. In the first scenario, the measure will be compatible if the beneficiaries pay at least the European Commission minimum tax level, and the measure is granted in an objective, transparent, and non-discriminatory manner. In the second scenario, the European Commission will review the necessity and proportionality of the measure. Reduction or exemption from funding support charges for electricity from renewables are somewhat different. The guidelines include a specific compatibility criteria and only permit such measure in certain specified sectors. Reduction in or exemption from environmental tax can at least indirectly contribute to a higher level of environmental protection. However, the overall objective of the environmental tax to discourage environmentally harmful behavior should not be undermined. The tax reduction should be necessary and based on objective, transparent, and non-discriminatory criteria. Harmonized environmental taxes. Member States can grant the aid in the form of the reduction of the tax rate or as a fixed annual compensation amount or as a combination of the two. The European Commission considers aid in the form of tax reduction necessary and proportional if the beneficiaries pay at least the European Union minimum tax level, if the choice of the beneficiary is based on objective and transparent criteria, and finally, if the aid is granted in principle in the same way for all competitors in the same sector if they are in a similar factual situation. Non-harmonized environmental taxes and a specific situation of harmonized taxes. If the beneficiary pay less than the European Union minimum tax level, the aid will be assessed on the basis of the condition for non-harmonized environmental taxes. For all other non-harmonized environmental taxes, and in the case of harmonized taxes below the Union minimum levels, a member state should clearly define the scope of the tax reduction. In this case, the aid is considered being necessary if the choice of beneficiaries is based on objective and transparent criteria, and the aid is granted in the same way for all competitors in the same sector if they are in a similar factual situation. If the environmental tax without the reduction leads to a substantial increase in production cost, and if the substantial increase in production cost could not be passed on to customers without leading to significant sales reduction. The aid will be considered being proportionate if aid beneficiary pay at least 20% of the national environmental tax, or if the tax reduction is conditional on the conclusion of agreement between the member state and the beneficiaries or their association. In this case, the beneficiary or association must commit themselves to achieve environmental protection objectives which have the same effect as if beneficiary pay at least 20% of the national tax or if the union minimum tax level were applied. Such agreements must satisfy the following cumulative conditions. The agreement is negotiated by the member state and specifies the targets and its schedule. The member state ensures independent and timely monitoring of the commitment concluded in the agreements. And finally, the agreements are revised periodically and stipulate effective penalty arrangement applicable if the commitments are not met. And finally, I allow myself to make a final remark. Energy taxation, when given the right incentives, plays an important role in reaching the due objectives. However, the adoption of national tax incentives might hit one of the keystones of the European integration, the maintenance of the fair play level of competition within the internal market. When deciding on which tax scheme to apply to the electricity sector, member states must be fully aware of the European Commission position on state aid and set up the regimes comply with the guidelines. Mainly, member states are free to design their support regimes, but they must notify state aid does not benefit from exemption or apply to the European Commission for approval. Otherwise, such aid cannot be granted. I thank you very much for your attention. I give back the word to the chairman.
Thanks very much for your interest presentation. The idea of having this presentation first is also because it is connected with the different issues that will be then addressed, both within this session and also later on. But there is one more interesting point that we should have at the very beginning, and that is looking at the development of COP21 and the climate changes concerns, and exactly understand what can be the role of tax incentives among other economic instruments. And for this reason, we have thought of having Iñaki Bilbao's presentation second, so we just change a little bit the order that has been announced in your leaflets. So, Iñaki, the floor is yours. I do not know whether you want to stay there or move closer to the...
It's not necessary.
Okay, right. Iñaki, please.
My goal is to be very brief and introduce the topic and give a framework in order we can later on go deeply with the problem caused by the lack of an international agreement around a carbon pricing system and the connection with energy taxation and other economic instruments. Thank you. As you know, climate change is a global challenge that reaches beyond national boundaries to the collective institution of the international community. But in the light of the inefficiency of unilateral national policies, a major international agreement is needed. But even if we have an international agreement, there's a lack of international consensus about a fair and reliable carbon prices systems that makes more difficult fighting against climate change. As we will see, COP21 in Paris has not changed very much this scenario. As you know, in December 2015, we have a final agreement. I'm going to focus on mitigation, even there was other important topics related with adaptation and the need of international funding in order to help fighting climate change. But I will focus on the main points of the agreement and related mitigation in order to give you a framework of the problem that I think we face with energy taxation. So, all the signatories agreed to reaffirm the goal of limiting global temperature increase well below 2 degrees Celsius, while urging efforts to limit the increase to 1.5 degrees. And they also agreed to establish binding commitment by all the parties to make national determined contributions and to pursue domestic measures aimed at achieving them. But there was not binding reduction emission target. So there's no emission reduction target for countries in the COP21. It will be depending on the national determined contribution, what will be the reductions aimed by each country. Also, it was agreed that parties may use international transfer mitigation outcomes it was preferred not to use the term emission trading scheme, as some country doesn't rely on this system. And even if it was qualified as success by international community, and even if it's a progress, it doesn't solve our problematic scenario. Why? As international business are claiming, we need, I think, a fair and reliable carbon pricing system in order that all the countries, all the companies are facing the same problems. For this matter, we have different instruments for this carbon pricing system. We have taxation, energy taxation, CO2 taxes, emission trading schemes, and tax incentives for CO2 reduction, for carbon reductions. The problems arising from different carbon pricing instruments at different levels, local, national, and regional, are presenting different consequences in the problem faced at adding different instruments. Why? Because they are adding more pressure to the different economies. We are risking of overlapping regulation and distorting effect, and also a problem of poor coordination between approaches that may lead to environmental inefficacy and loss of economic competitiveness. For this reason, I would like to introduce which are the three main roles that tax incentives should have in this field. I think there are three main roles this tax incentive may face in the actual scenario: is combination of instruments to prevent distortion, protection of competitiveness, and stimulates carbon reductions by renewable energy, energy efficiency, carbon capture and storage, and clean development mechanism and joint implementation projects. However, in the European Union, these tax incentives have to be analyzed through state rule, and we have to reflect about the different interests to protect or prevail: competition, coordination of instruments, competitiveness, tackle climate change, or guarantee energy supply. That's why we have to think about if all the state rules limitation for introducing all these tax intensive can become a problem for the EU members for difference of these topics. Thank you very much, and I wait for your question later.
So the title of my presentation is Tax Incentives in the Energy Sector, General versus Selective Measures. And I would like to take this opportunity also to link my remarks to what has been said by the previous speakers of this panel, and also by the first panel and the introductory session this morning. I think it's important to understand that if the European communities were born on the sharing in a context of sharing of energy, then we really need to understand that this is something important for supranational law of the European Union, and the results that we have achieved until now have to be critically reviewed in the light of the possible legal constraints that are established within the European Union for the purpose of protecting and pursuing goals that are important for supranational law. So we understand that there is a growing global concern, but we also understand that within the European Union we have an issue of avoiding the relocating effects to outside of the European Union. So it's a little bit difficult sometimes. There is this kind of friction or tension between two goals which are perhaps both equally important, which is protection of competition and an effective reaction to the sharing of energy. And we have to be critical, because I think it's time has come to understand that the environment is a global matter or is a matter of global concern, in particular after COP21, that we have some global goals to achieve. And the fact that we may have national policies in this respect, it's something which is perhaps to be reconsidered. And that is something also connected with the fact that tax incentives generally pursue some specific goals. So if you change the overall framework in connection with the levying of taxes, and you try to have a preferential treatment in some specific cases, you have to justify that in the light of constitutional principles. And these are issues that this conference we shall be addressing in the very last session from on a comparative basis. But for us, it is important to understand that there can be right now different fiscal policies in the different states of the European Union, and at the same time, the exercise of taxing powers must comply with European supranational law. So these preliminary questions that I am addressing in my presentation are, in my view, important to understand what we want to achieve and what the situation is right now. So we have a situation to some extent which shows a fragmentation among different policies. So we have goals that are better pursued by some countries which have higher standards for energy in the energy sectors, and other countries which have different standards, but then at the same time all of them have to comply with primary European law. So we also have to understand that within one and the same internal market, we may have difficulties if some countries have higher standards of environmental protection and some others have lower standards. So whenever the countries with higher standards of environmental protection want to try and intervene for the purpose of fostering some activities that in their view are worth being pursued, then there will be automatically a different treatment as compared to the general one, and therefore there will be this potential problem with state aid. Luis Cazorla as rightly mentioned before, that only some of the energy tax incentives qualify for the general block exemption regulation. I will not get more into these details because that is exactly the focus of Joachim Englisch's presentation. But I think that we have some structural problems, and the decision-making process has to take into account that if we have global problems and if we want to avoid the relocation of activities that may be are energy consuming, then we also have to take these into account and to try and come up with a comprehensive reaction. The impact of primary law on tax incentives is therefore to be seen in the light, on the one hand, of the desirability of having an EU-wide energy policy, as Ferran Tarradellas said at the beginning of today's session, and the limits and the protection of free competition of the market. One important point is that we should really question, and this is perhaps something which I would like to have. I hope you don't mind if I'm mixing my two capacities as speaker and chairman of this session. We should really ask ourselves whether we should have fiscal policies for the environment and in respect of energy at the national level. From these statistics that were presented at the beginning of today's session, we also saw that some countries have higher energy deficits than others. So it's not all a matter of protecting free competition, but also the fact that some countries have different needs from others. And therefore, if they want to protect the environment at the same time, they don't have to forget that they have stronger need to gather energy. So from this perspective, and also taking into account the points that were made by Íñigo del Guayo in respect of the renewables, I really think that that in a way, even if one country has stronger needs, and we can easily talk about the example of Spain, which was called an energetic island, and it was a different spot in the chart that Ferran Tarradellas showed before. I think this is not just a Spanish problem. This is a European problem. So if we really want to have an energy policy, we should avoid to some extent that different parts of the European Union can have the right, or they can be more concerned about some aspects than others, because otherwise we can have this market fragmentation effect. So the energy policy problem is a problem of the European Union, and it's a problem of the European Union even if some countries have less problems than others, because at this very moment we have to understand that the existence of different policies can have some impacts on the competition on the market. Of course, I am trying to be provocative. Please remember that the idea of this conference is also that we go beyond also the papers that we have presented. Of course, these are some of the issues that Iñaki and I have already put in our paper that we have presented in one of the seminars. But I think if we are all here together, then it's really worth to be a little bit critical and understand if fiscal policies can be still pursued at the national level in respect of energy and the protection of the environment, or the pollution, or whether there are the problems that I have mentioned. So again, the luxury is that we have time for the debate. So this is not just a formal, request for interaction, but it's also to try and provoke you a little bit to have a more interacting part at the end of my presentation. So there are essentially 4 issues that I am addressing in my presentation. The first one is tax incentives and the environment in the European Union. The second one is the establishment of goals and priorities at EU level. The third one is what I call towards a global approach, how the EU relates to the rest of the world in respect of the energy sector, in particular insofar as concerns tax incentive. And then, of course, once we have addressed those points, the issue is how we implement them. So, we have already heard in the first session that there are structural issues, and I think it was Isabel Martinez who mentioned that. The issues are preserving sustainability and competitiveness of business while enhancing environmental protection. So, from this perspective, if we have a market in which we set higher standards of protection of the environment, then that will potentially lead to a dilemma. And the dilemma is if all players follow, if all business entities play by the same rules, then this can potentially generate some positive effects. But perhaps some business players do not want to play by these rules, and they relocate a part of their activities in other countries, and therefore, the preserving the competitiveness of business is a little bit difficult, because the players who stay in a country and operate from that country will be in a more difficult situation than others. And at the same time, we also have to understand that we cannot talk in general about these problems, but we have to take into account the different types of taxes, because some taxes have an impact on the relation with the final consumers, and some others have a relation which is more directly connected with business. So I think perhaps as a kind of conclusion in respect of this first bullet point of this slide, we have perhaps to take a different issue according to what type of tax we are talking about. So if we're talking about indirect taxes, which is a term that tax people generally use for taxes which are connected with consumption, then we can have one reaction. And if we're talking about direct taxes, such as the one on income and capital, then we can reach a different balance. of course, the competitiveness of business is affected to a different extent in respect of the two different types of taxes, because in the one case you can shift taxes, in the other way you can do it in different ways. So we have also to take into account that if we want to have taxes on the consumption of energy by private persons can normally not relocate, or they don't relocate just because there are higher taxes on energy consumption, but business can relocate, in particular in areas where you have some possibility to do so, and within the European Union that is also quite normal. It is quite clear that in this field there is a favor for intervention through market-based instruments, one of which are actually taxes. And I think it's no longer the time to talk about whether tax incentives should be used, because there is quite some consensus that tax incentives are to be used as one of the tools to reach the objectives of Europe 2020. So even if there are discussions between lawyers and economists as to the potential relevance of tax incentives in the cross-border scenario, tax incentives are to be used. But I think it's important, earlier today, the point was made of the fact that there is some contradiction between policies. This is Íñigo del Guayo who said that. Contradiction between policies, because one country can take a type of measure and address a problem one way, and the other country can perhaps also take a different measure, or a different measure cannot be reconciled, and therefore some of the positive effects of tax incentives are washed out by the other country. This is a matter which we see quite a lot at the cross-border level, and this is a matter also that has been addressed in the book that we have just published and that Marta has been showing in the morning. So the idea is that if we have global goals, and one country does one thing and the other country tries measure to counter what the one country has been doing, because that can perhaps be a good way to levy some additional taxes. Well, what do we have here? We have here an action which is just a waste of time. Of course, we levy taxes because we want to collect some revenue, and each country can say, I want to collect some revenue, and I have to try and find a way also to avoid that people who operate in my country are not competitive with the others. But this unilateral reaction really doesn't make sense from the perspective of achieving the global goals of environmental protection and a consistency in regulation of taxes. So this is, also one of the reasons when we decided to start this research group with Marta, we thought about talking about the importance of coordination. So we are to set some standards, we have to decide what are the instruments that we want to use, and then try to implement them consistently. For us in the European Union, the fact that we have supranational law shouldn't be a limit or a legal constraint, as we call it, but it should rather be an opportunity to bring some action from the national level to the level of the European Union, because that is a way at least to avoid that we have some inconsistency, or that we have this conflictive reaction between measures taken by one country to promote the energy sector and the other country which is taking some countermeasure. I'll say something towards the beginning of my presentation this morning, but this is already to give you an idea to the fact that we have to take a position in this respect. If we are to go for reaching global goals, then the European Union should act as a bloc. Ferran Tarradella said that because the European Union acted as a bloc, that was also quite important in pursuing other states to take some measures. Of course, the European Union is a big energy importer and a big polluter in the world. So the fact that the European Union has a problem and acts together then can be important to achieve the goals that are connected with the enhancing of the environmental protection. So yes, we are using taxes in the energy sector to collect revenue, but the fiscal goals should be prevailing over the remaining ones, and that is something that is important because when we talk about incentives, the role of the incentives is to alter the behavior of market players. So if we want to alter the behavior of market players, we should be consistent in altering the behavior in a way that is not washed out by the actions and reactions, just like, you know, the waves near the river, when a motorboat moves, then you have waves going in all directions because the river is not too wide in some cases. So I think, you know, that this is one issue that should take us also to achieve some clarity as to the impact of tax incentives. So we are an interdisciplinary research group, and Carmen Calderon already was, you know, making some remarks to what can be effective and what cannot be effective. So I think, you know, it's quite important also that we achieve clarity as to the impact of incentives. So we should measure the incentives, and my point is that we should measure the incentive from the perspective of the impact on the energy sector. So if we have one desirable goal, and the desirable goal is to achieve with an energy policy a sufficient, let's say, supply of energy, and we know that this is a priority, as we heard it earlier today, then the impact should be measured from that perspective. How much, how successful an incentive has been from the perspective of securing energy supply or solving the problem that we have in some parts of the European Union, and also taking into account the impact of the environment. Of course, you know, if we do this, we have, in my view, also one additional advantage. And the additional advantage is that if the impact on the environment is clearly visible, then we will have to spend less for the protection of the environment because we cause less damages or less harm to the environment itself. So I think, you know, when we talk about the double dividend, more environmental protection and more revenue, when we look at the more revenue, we should also take into account a combination of what in Spain people normally call the financial law side and the tax law side. So not just the taxes, but also how much we spend in respect of the protection of the environment. If we cause less harm to the environment, then, you know, that is perhaps something which can and should be taken into account. When I say should be taken into account, I also say should be taken into account for the perspective of measuring state aids and determining what is a general measure and what is a selective measure. So I think, you know, these are additional points. Iñaki and I have been already including some of these remarks in the paper. You know, Marta said earlier today, all our papers are with open access policy, so anyone can have a look at what we have come up with. So it's not just in the book that we have published, but also in the papers. And I think, you know, this is one important point. When we look at the double dividend theory, we should expand one of the two dividends. We should expand one of the two dividends for the purpose of understanding that if we cause less harm to the environment because of a energy policy that achieves some goals in a more consistent way, then that is also something important. And this is, in my view, also important to understand what is a general measure and what is a selective measure. Of course, you know, from a tax perspective, purely we can go to the very basics and say, well, if you reduce taxes in general in a field, that is certainly not selective. If you want to go with a targeted action, then that measure is selective, and therefore it triggers state aids, and therefore we have to try and understand whether that is to be admitted within the internal market and on the basis of what grounds. It is clear that if we change, you know, the idea of how we intervene in the energy sector, then we can consider that action in the general, in the energy sector, anything which is connected with the energy sector, can turn to a benchmark on its own. So you can say that since the protection of the environment and the energy policy is desirable at the European level, then the intervention is not a special intervention, but it's something which fits within the boundaries of a general EU energy policy, which is therefore giving the possibility to relax a little bit this selectivity analysis. We are all aware in the tax community that the concept of selectivity is rapidly evolving. And this is, in my view, nothing really bad. Everything evolves in European Union law, and also the concept of selectivity evolves in the European Union law. Of course, I don't want to go for an invasion in Section 3 and the following ones, but again, all sections of these conferences are related, and therefore it's also important that we try to find, let's say, our own dimension for the analysis of selectivity in the framework. I think it's clear that I plead for a framework of EU energy policy where the tax incentives, since we say that they are desirable, then we use them consistently at the level of the European Union. And I think, this is important to understand that if we have some environmentally friendly behaviors, then subsidizing them also in the form of reduction of taxes, it's something which can be desirable. Legal uncertainty is undesirable. Legal uncertainty is exactly what we have right now in tax matters with business, because of the fact that the selectivity analysis is evolving. And I am not saying that it's bad that the selectivity analysis evolves, but I'm saying that if I were an entrepreneur and I were to take some business decisions without legal certainty, let's say renewable energies, do I invest in that field? Or let's also think about interesting things happened between Sweden and Germany concerning the investment in the field of nuclear power stations and the protection of legitimate expectations for business, the change of policy decisions by a government. I mean, these are all points that we have to take into account. Of course, many of us are academics here in this room, so we're trying to do what is, the best thing, or, to discuss the best policy. But legal certainty is particularly important for the decisions of our business. Certainly, we have to achieve energy security or energy policy, but at the same time, if we don't develop technologies that protect the environment or that secure this the supply of energy, then I think we are negatively influencing the developing and the sustainability of the economy in overall terms. Or, the other effects is that they relocate. They relocate to other countries where there is more tolerance, and this creates the carbon leakage risk. And in fact, if we have a global problem, I think the European Union should be a trend setter, as I've indicated on the slide, a trend setter for promoting green energy. It's not just, getting polluting activities out of the European Union and somewhere else. We have to try and promote energy sustainability in a way that protects the environment overall, not just that pollutes other countries. But as I said, it's important to achieve this framework of ex-ante legal certainty. Otherwise, we harm business, and we cannot have an energy policy that harms business. The idea is that the tax incentives that can be used should at the same time subsidize environmentally friendly behaviors, coordinate instruments for protection of the environment, and prevent carbon leakage. So we are coming towards, we are reaching the third point of my presentation. I am a little bit more relaxed with time just because we are significantly ahead of time, and I shall use all my prerogatives as chairman to try and foster the debate, because there will certainly be no discount on the lunchtime. No, the idea is that if we have come from various countries, we want to use this time together as much as we can. So what are the possible ideas for a global approach? We have to think as to whether a general reduction in taxes can be more effective than selective incentives. Now, we really have to consider that if we see something, we consider that something is desirable and we take a measure to achieve this goal, then one may wonder, so isn't it normal or structurally appropriate that if we see a problem and we take a reaction to this problem, then the targeted reaction is better? So this is what we have possibly in the entire world. And so this issue concerning selectivity should be, in my view, framed within a general policy at the European level connected with energy. So it is possible that we reach the conclusion that tax incentives are normally selective and targeted and therefore more effective from a policy perspective. So if your finger is bleeding because you just cut yourself, then, if you do something immediately on your finger, then that will prevent it from bleeding further. Of course, you can do other measures and, you still achieve the same result, but then it depends on how big the effort should be. And of course, if you put your finger on the other finger to stop the bleeding, and then somebody takes your finger away, it starts bleeding again. So again, this idea of targeted, selective, consistent action at the level of the European Union is, in my view, something quite important to push forward this global policy for the energy sector. I must say that in line with the idea that I presented before, the problems of Spain with energy supply are not Spanish problems, are European problems. So I am here pleading against flexibility at the national level in the field of energy taxation. Against, because if we have too much flexibility, then we can have these effects of market fragmentation, and then of course also the tension for protecting the so-called level playing field within the market should be higher. So the idea is that if we want to go towards a European energy policy, national problems are European problems, so we should limit the flexibility at the national level, achieve an EU-wide standard which looks more like directives in the field of direct taxes. We always say that directives in the European Union are, in principle, they are addressed to the states, and the states must implement them in their national system. In the field of direct taxes, they are so specific that they have the so-called, in fact, direct effect in many cases. So I am pleading for reducing the flexibility at the national level if we want to achieve a proper energy policy, also in respect of tax measures. And another important point to build this bulk of measures or the European Union standard is that we have to achieve legal certainty. And the legal certainty can be achieved also by considering to what extent an EU-wide energy policy can be regarded as a general measure, and the fact that we have some specific incentives could be fitting within that framework. Marta has been elaborating also on the idea of giving reductions not by the states but by the European Union. It's not because I like Marta that I say I like this idea, but I actually like this idea because we have to try and understand what we want and what is desirable. And if, as I have been pleading for the past few minutes, we want to go towards an EU-wide energy policy, then I think that also the desirability of the so-called tax reductions by the European Union is something which could be potentially important, and those would no longer be advantages given by the states, but it would be advantages given by the European Union. You know, many countries of the European Union are getting EU funds because the European Commission considers that those countries have to do something for their economic development, so the European Commission intervenes in order to promote public intervention and remove the differences existing across the Union. So the European Union Commission could be doing that also in the field of energy. And that is something which I am putting forward, I'm putting on the table, supporting the argument made by Marta, to see also your reaction. And if we go this way, how do we implement that? Of course, you know, you must have been waiting for me to say broadening general block exemption regulation. And guess what? It is on the slide. Of course, because I like the idea that through general block exemption regulation, we can get legal certainty. And we can reduce the discretionary powers, and we can reduce the negative impact on predictability of what could be important for the entrepreneurs. So I'm not saying that we should kill the energy business. We should actually create or strengthen the energy business. And we should have the possibility for entrepreneurs to say, well, the legal environment has changed, and we adapt to that, and we take a new opportunity for doing business in this field. And, as I said at the beginning, please remember that I said, you know, there is no one size fits all reaction. We have to take into account that different impact could be expected in respect of tax incentives for direct taxes and for indirect taxes. I think that for indirect taxes, there could be tax and non-tax measures. So we could also act at the social level, just to understand that for products coming from countries that do not comply with the standard, there could be a reaction also by the consumers themselves. But of course, you know, when it comes to direct taxes and the competitiveness of business, we cannot change the behavior in this way. But in my view, and this is summing up also the point that I have been illustrating in my presentation, because, you know, I don't have to exceed with the time that is given to me, because I should be the moderator myself, so I should be moderated. But the point that I would like to make is that, in essence, the European Union can more consistently achieve an energy policy to the extent that it reduces the flexibility at the national level, and it takes all different needs by the states in the framework of an overall policy that reduces these inconsistencies and achieves a higher level of legal certainty. The broadening of the general block exemption regulation in this framework could be connected or a consequence, or could be also a development that we could achieve at the level of interpretation that is important in order to see how the European Union can contribute to a policy in the energy sector that fully exploits the advantages of the tax incentives without being chased or without being locked in a cage by legal constraints. Thank you very much for your attention. Back to Dr. Jekyll and Mr. Hyde, so changing chairs, changing function. Now it's my time to get back to my role of moderator, and it's time for us to hear the presentation by Joachim English on energy tax incentives under the general block exemption regulation. Joachim, the floor is yours.
My presentation will focus mainly on two aspects. First, I would like to give an overview of the current requirements under the General Block Exemption Regulation for the notification requirement of Article 108 of the treaty to be waived in case of energy tax incentives. And second, I would like to discuss with you whether a reform is actually needed. From my perspective, at first sight, I might come to different conclusions as compared to Pasquale's conclusions. I think in principle, actually, we should maybe restrict a little bit what is possible under the GBER, but in the end, there might be an argument indeed for having it even broader than it is now, and we shall see how I will try to develop that idea. I should also point out to you that I will concentrate on incentives in taxes that are harmonized by the Energy Tax Directive. Why so? Well, because on the one hand, almost all energy taxes that we find in member states are actually covered by this directive, including carbon taxes, and only some exotic taxes, such as on nuclear fuels, are not covered. So I will focus on the harmonized ones, also because, as has already, I think, been pointed out, the general block exemption regulation is only applicable to such harmonized taxes or incentives in the framework of such harmonized taxes. Okay, the preliminary reflections I will mainly skip because I think Luis and Pasquale have already said everything about the state aid framework into which the GBER is embedded, and also the important aspects of state aid analysis in the context of energy tax incentives. Just two brief comments to what has already been said before. I think also that it's an interesting idea, and it would of course make life for all of us a lot easier if Marta's idea was picked up and we would have mandatory exemptions or tax rate reductions at union level, because then we don't have a state aid issue. There is, of course, coming a little bit also from a VAT corner, a certain danger to that, as long as we have a unanimity requirement at the European level for anything concerning tax, that we see a petrification of certain exemptions being fixed at one point of time in a certain, economic and social framework, and then maybe 20, 30 years later it turns out that we would have to change that, but it results difficult because member states, 28 of them, cannot agree on how to change, what to change. So this is the downside of having it harmonized at the European level, I think, as long as we do have unanimity at least. And we can see that clearly in the VAT field, I think. And the second point I would like to make is that I also agree with Pasquale that we need to take into account the environmental objective of energy taxes when judging whether certain incentives are state aid at all, because if those incentives precisely pursue certain environmental protection objectives, then it makes perfect sense from the underlying principle of the tax to have a lower or no tax burden on these kinds of uses of energy, and this should not be considered aid in the first place. Well, but I'm supposed to talk about the GBER, so I will now give you a bit more of an overview of the legal framework concerning this particular regulation that has been done so far. First, I think most of you will be aware of that the GBER has been enacted by the Commission based on an authorization that we find in the so-called Council Enabling Regulation, which has been codified in 2015. However, as regards energy tax incentives in particular, this codification of 2015 doesn't really bring about any changes as compared to the situation prior to the codification, which was the 2013 amendment to the original enabling regulation, which in turn is based on an authorization provision in the treaty in 109. What is important and what has already been briefly mentioned is that we do find in this enabling regulation, so in the authorization by the Council to the Commission to waive the notification requirement for certain types, categories of aid, altogether 14 categories of aid that qualify potentially, according to the discretion of the Commission, for a waiver of this notification requirement because they are a priori considered compatible with the internal market. And in fact, the one that is most important for the current GBER regime is the possibility to waive the requirement with a view towards aid in favor of environmental protection. We do also find 13 or 14 other categories of qualifying aid. However, none of those is really relevant for energy tax incentives, not even potentially. except for maybe two, and that is aid in the form of aid in favor of forestry, and also aid in favor of residents of remote regions, but these are really rather marginal issues. So the main point here is that the Council regulation authorizes the waiver regarding aid in favor of environmental protection. This is what the Commission relies on, as we shall see, when it comes to energy tax incentives. And finally, then there is, of course, the GBER, which has been modernized in 2014. Originally, it's from 2008, and the 2014 modernization reflects the 2013 changes of the enabling regulation, but again, as regards tax incentives, it's mostly about clarifications, not really about a change in strategy. Now, Luis has already, I think, pointed out briefly the main requirements under the regulation, the GBER, that need to be fulfilled for a certain aid scheme, to the extent that it is actually state aid within the meaning of 107, to qualify for a waiver of the notification requirement. But I would like to go a bit more into detail now and also point out to you the rationale underlying these requirements that we find in the GBER. First, just like any kind of aid measure that seeks qualification for the waiver of the notification requirement, the energy tax incentive would have to comply with the formal requirements that we find in Articles 9 and 11. So the Commission must be notified electronically, the measure must be published online, but this is a hurdle that any measure should be able to take. What is then important is that the tax relief must concern an environmental tax as defined in Article 2 of the GBER, and that means it must send a price signal, so internalize external costs of economic pollution, environmental pollution, or it must address in its tax base behavior that is negative for the environment. And what is interesting to see is that, in my view at least, all the energy taxes that are harmonized, that are covered by the Energy Tax Directive, can actually be presumed to constitute such environmental taxes within the meaning of Article 2, even if the national legislator does not explicitly specify that in the national legislation. And I think this can actually be inferred from the preamble to the Energy Tax Directive, where it is made quite clear that from the perspective of the Union legislator, energy taxes fulfill an important role in European environmental policy. Any kind of energy tax does that, and therefore this applies to any kind of tax that is covered by the directive. And this has indeed also been the opinion of the Advocate General in the recent or still pending case, Dilly's Wellness Hotel, which should be decided, I think, towards the end of this year. So essentially, this is not a requirement. When the energy tax incentive is an incentive that is contemplated by the Energy Tax Directive, then it concerns an environmental tax. So this is no real additional requirement, apart from the requirement that we find in Article 44, that it must indeed be an incentive contemplated in the tax directive. It has already been mentioned that the tax relief, in order to qualify for privileged treatment under the GBER, must not fall below the minimum taxation levels fixed in the Energy Tax Directive. If that is the case, the incentive effect that normally must be demonstrated by the member state in order to get privileged treatment under the GBER will actually be presumed to exist according to Article 6 of the GBER. So again, another ease of requirements. If minimum taxation levels are respected, there is no need for the member state to still show that there is an incentive effect. It's just presumed to exist. It has also been mentioned already that the beneficiaries must be selected based on transparent and objective criteria, and we find a specification of what that is supposed to mean again in the preamble to the GBER. It is quite clear that consistency is required as to the implementation of the objective of the incentive, And furthermore, competitors should not be distorted, or competition should not be distorted as between competitors in a similar factual situation. And finally, the aid should be granted in form of a tax rate reduction or fixed compensation amount. However, this will usually be the case anyways with respect to incentives covered by the tax directive and respecting the minimum taxation level. So again, this is not much of an additional real requirement, which brings me to the conclusion that essentially it's just two conditions that need to be fulfilled with respect to any kind of tax incentive contemplated in the harmonized energy tax directive, and that is the requirement that the minimum taxation level must be respected first, and second, that the granting of the aid must be based on criteria of transparency and objectiveness. What is interesting, I think, is to reflect a little bit upon the rationale underlying this relatively generous treatment, which will then also bring me to my critical assessment of this regime that we have now. It seems that it's not so obvious that any kind of energy tax relief should be regarded, and this is what the Commission's view, however, is, as aid in favor of environmental protection. And remember, this is mainly what is allowed by the enabling regulation. Other things are not allowed. So how does the Commission argue here? Why would a reduction, for example, in tax burden for energy-intensive industries be considered aid in favor of the environment, while the effect is that the industry will go on polluting more than if energy tax levels would be higher? At least at first sight you might consider this to be the case. Well, it's that the Commission assumes that member states would reduce the overall level of taxation, of energy taxation, if they were not permitted to grant these kinds of specific benefits, because the Commission assumes these benefits are so important for member states' policies that they would rather lose a lot more revenue than avoid granting this incentive. So the idea is really they would lower the overall tax burden rather than not having a low tax burden for specific sectors. And that brings the Commission to the obvious conclusion, based on this kind of perspective, that it is better to have targeted relief rather than an overall reduction of the tax burden, because the latter would be even more harmful for the environment than just a targeted relief. And it's then also clear that from this perspective, it makes certain sense to require that minimum taxation levels are respected, because even if the member state were to go for the alternative, the theoretical alternative of lowering the general tax level, it could not go beyond, of course, lowering it beyond the minimum taxation level. And so the Commission says, well, then in that case, also the targeted measure should not go below that. There is no need for it to go below that, based on the logic of the Commission, which says the alternative to the targeted measure would always be a general lowering of the overall energy tax burden. I'm a bit critical with that approach, actually, for several reasons, as I shall try to point out. I think the exemptions that we find in the GBER should actually reflect what the Commission itself termed the refined economic approach that the Commission has committed to in its state aid assessment, and that, as we have heard, I think is also underlying the guidelines for state aid in the environmental sector, or with environmental protection purposes. And under this refined economic approach, it is necessary to balance the positive effects of aid, so the achievement of certain objectives in the general interest, such as environmental protection, against the potentially negative effects or side effects of aid, especially the distortions of competition and trade in the internal market. And what should matter, therefore, is on the one side, how effective and targeted is the aid measure really to achieve its respective objective, on the one hand, and on the other hand, how grave are the distortions caused by this particular incentives, and which of course is related to the extent of the aid granted, so the amount of aid granted as well, amongst other things. And I think this kind of balancing exercise should also inform the waiver of the notification requirement under the GBER, because only if already from an abstract analysis, without going into a case-by-case analysis as would normally be required under the notification requirement, it can be assumed that the measures will be targeted on the one hand, and on the other hand will not cause grave distortions in the internal market. Then should it be possible to waive the requirement of a case-by-case analysis by the Commission and just go for the general exemption under the GBER. And if we now look at what we find, still have a few minutes? Possible? Yes. Yeah, okay. Okay, thanks. What we find in the GBER now, I'm not convinced that the approach chosen by the Commission is so rational indeed. Because first, I think we should judge tax incentives, energy tax incentives, on their direct objectives only. So these direct objectives should be judged in their own right. It is, in my view, not realistic to assume that any and each kind of energy tax incentive would be so dear and important to the member state that it would rather lose a lot of tax revenue, rather lower the general level of taxation than not grant this particular aid or this particular low level of taxation to a certain sector, especially so because often there will be other alternatives. The alternative might not be to lower the general level of taxation, but rather to, for example, grant direct subsidies to the affected sector. So if you think of aid, which we find in the energy tax directive, in favor of public transport, so fuels, motor fuels used for public transport, or aid for certain charitable activities, I don't think that if a member state were not allowed to have this aid in form of energy tax reductions, the member state would say, oh, now we will lower our entire energy tax level just to be sure that public transport doesn't pay too much for in terms of energy taxes. They might just go on subsidize public transport a bit more and compensate this way. So I think it's not realistic to say any kind of energy tax reduction is always indirectly benefiting the environment because it prevents that the overall level of taxation is lowered. I don't think that is convincing, and I think therefore that energy tax incentives should be judged and assessed with view towards their effects regarding their direct objectives, such as promoting charitable activities, promoting public transports or other social considerations such as heating for poor households, and so forth and so forth. Now, admittedly, in a few instances, the Commission's logic is actually convincing, probably, but only in a few instances, and I think the most important one is obviously tax benefits for energy-intensive industries. I think this is so crucial for many member states with such industries such as aluminum or in general metal industries and so forth, that they would indeed rather lower the general level of taxation than not have or than impair the competitiveness of their industries. But as regards this kind of incentive, where it might make sense to judge them as indirect aid to the environment, I think this is also precisely the kind of incentives that are problematic from a refined economic approach perspective, because they cause grave distortions of competition, at least potentially, and they're certainly aimed at having an effect on competition in the internal market and beyond. So I think, in principle, a case-by-case analysis of the Commission would still be needed based on the refined economic approach. And that leads me to my maybe a bit provocative statement, but the Chairman asked us to be provocative a little bit, that at least at first sight, the block exemption regulation is actually maybe right now too generous rather than too restrictive. To allow for some debate, I think I should be brief now. My suggestion, therefore, is judge energy tax incentives, in principle at least, based on their direct, immediate objectives rather than on this idea of indirect environmental protection, and therefore include a few more objectives in the GBER where it can really be assumed that the distortionary effects will be small, such as benefits for social reasons or for charitable activities, or maintain those, for example, for remote areas. This is all marginal stuff that will not be harmful to a great extent for the internal market, so it should be included in the GBER and it should be allowed by the enabling regulation. And as regards such benefits, it wouldn't make sense even anymore to require that minimum taxation levels are respected. If we give up the logic of the Commission that everything is indirect aid to the environment, then we don't need this criterion of maintaining minimum taxation levels anymore too. Whereas the criterion that the design should be non-distortionary and so forth should be maintained. And as regards the incentive effect, the standard approach that we find in Article 6 of the GBER should be followed, so it should not be assumed that there is an incentive effect, but rather it should be checked whether tax administrations have any administration, and if so, we cannot be sure that there is an incentive effect. But what's most important maybe is that at least at first sight, the conclusion would therefore be that regarding all other kinds of aid, and especially also aid for energy-intensive industries, granted, of course, on a state level rather than as union aid, there should be a case-by-case analysis by the Commission under the notification procedure rather than a waiver of notification under the GBER. Unless we would argue, and this is something I think might be worth a debate, I think I would be probably inclined to say so, but I'm sure it's controversial, unless we would say that anything that we find as optional in the Energy Tax Directive, but to which distortionary effects are already inherent, such as, for example, the authorization in the Energy Tax Directive that member states may, but not must, may grant reductions for energy-intensive industries, that this should then also not require an additional scrutiny by the Commission, because actually the Commission and member states working together when enacting the tax directive have already taken into account the negative distortionary effects and have come to the conclusion that for the benefit of, in this case, environmental protection objectives, these distortions should be accepted, and therefore there is no need to review this again by the Commission. To the extent, however, only that member states do not come up with additional conditions which would cause additional distortions. In that case, in any event, there should still be a case-by-case analysis. So that's it from my side, and thank you very much.
Thanks very much, Joachim, for your presentation, for being provocative. And now we have exactly 11 minutes for the debate, but I have also a couple of announcements. So I'd rather go first for the announcement, and meanwhile you can raise your hand for the debate. I would like also to have a structured debate, so on some of the points that we have mentioned, so that it's less chaotic. Javier Porras has just given me some information. So right at 13:30, which is when this session will be over, we'll follow him and Monica and Carlos upstairs for lunch. Everyone is invited. And then we reconvene at 14:30 for communications. There will be 2 blocks. One will be chaired by Miguel Muñoz Pérez here in room 1, which is here, and the other one by Javier Porras in room 2, which is the Aula Magna upstairs. And that session will last until 15:30, so it will be a 1-hour session, and we have 4 to 5 presentations in each of the 2 rooms. So I have done what I was supposed to do. Now I would like to spend the remaining minutes for the debate. And in fact, we have raised a few issues which could be, could be worth to discuss together. One of these is, should we go for an EU-wide energy policy which reduces the flexibility at the national level? Or should we keep the situation as it is? So this would be the first point. I would like this debate, even if this is a tax session, I don't like even tax sessions to be too tax technical. This is not the spirit of this group. The spirit of this group is to be interdisciplinary. So, taxes can be a tool to implement some goals, but we have to understand first what we want to achieve and whether this goal is, in your view, desirable. So, is there anyone in this room who would like to make a remark? Álvaro Antón.
Thank you, Chairman. I also want to take chance of the opportunity that you give us to be a little bit provocative. So, following your presentation, I wonder if maybe when we study state aids, taxation, and the energy sector, I think that maybe we are departing for a statement that is not 100% true, or that we should question it. Is that the fact that the Commission says that environmental and energy state aids are put at risk the internal market and the competition. And I say that because maybe, which in this field, in the environmental protection and energy policy, maybe in Europe what we face, and which is really a danger for the internal market, is the fact of not having a real harmonization, especially in the economic instruments used to correct some market failures and promote some policies. And from this perspective, maybe state aids are the only way to try to solve some inefficiencies and inefficacies that this lack of harmonization brings. And this is something that we have to bear in mind, because I think that we should be more surprised in Europe to the fact that a country that is Sweden can introduce a CO2 tax, which of course will put their companies in a worse position than a country that doesn't have this kind of tax. But at the same time, and in this case, from the European level, we cannot do anything about it. But if the same country introduces some kind of tax release in order to avoid competitiveness issues or problems, then they have to face with all the state aid regulations and barriers. And this is something that we have to bear in mind so much, and we take it so in granted that these things have to be, but maybe we should start to question also this position.
So that is a point which to non-tax people cannot be perhaps so evident as it is to tax people. We have many times this feeling that nothing changes and that we do not manage to have a structured policy, therefore we live it up to the state aids or fundamental freedoms because we are simply unable to do something consistent with what we think is desirable. And this gives us a kind of feeling of frustration, which is in fact what Alvaro has been expressing before. But again, if we have something which we identify as desirable, and if the two of the three communities were done to set up to share energy, then I think we should try and go for an energy policy, and tax turns to be a tool for achieving this goal. Now, almost at the same time, Iñaki and Marcos raised their hand, and then Jerónimo, and then I believe Susanne Åkerfeldt. So Iñaki is giving way to our non-EU colleague Marcos Catao from Rio de Janeiro, and Marcos, I think if you shout, then it would be appreciated. Otherwise, we have to try and get your microphone, please. Well, the microphone can also travel this way. Yes, yes, I know you can. That's why I was,
Yes. Okay. Is the microphone? Yes. First of all, congratulate Marta and you, Pasquale, and everybody. I think the event is superb. It's a very nice subject, very technical, but at the same time, very contemporaneous, and then very nice. Congratulations. No, my question, I try to be not so technical, Pasquale, especially because I used to work for an oil and gas company. And then my question is, you said something that for me is in the main focus of those discussion. Is it energy something, is Spanish a national issue, a national that should be treated on a national basis or not? No. Why? Because in the end, the countries, they have their own natural tend to energy. I mean, if you go for sure for Arab countries, they produce oil. If you go to the United States, they're now producing a lot of ethanol. And then in our case in Brazil, for instance, we for a long time we have a huge deficit in terms of oil, and then the last 30 years we start to produce a lot of ethanol. What happened? The government induced the country, not the companies, but the consumers to consume ethanol. So the question is, and for sure I'd like to make a question for for you, no? Because in the end, as you said, Pasquale, and I think that Joaquin mentioned in the end of his speech, we tend to approach those issues in should we grant a tax incentive or should we grant a subsidy for public transportation instead of grant incentives for oil or something, no? But in our case, and for sure this is not a xenophobic approach in Brazil, we have a lot of problems in terms of energy, but what happened in the last 30 years in Brazil? Instead of granting incentives for some kind of energy, instead of granting subsidies for some kind of energy, we induce the consumption of one specific product, which is in case ethanol. So my question is, in my country, we can do that. How it works in Brazil? Because Brazil, the cost of produced oil in Brazil is around $40, no? The cost of produced ethanol is around $30. So when the price of oil is very cheap, it's better to produce ethanol. And then what happened in Brazil? The liter of naphtha in Brazil, now you must have 20%, but the government is able to balance the level of the percentage of ethanol in the gasoline. The government is able to balance the level of biodiesel in the diesel, no? So my question, I think this is a very intelligent way to approach the issue, but in case of European Union, is this possible? I mean, because you have so difference between the countries, among the countries in Europe, it will be possible to have in Europe an approach like we have in Brazil? I mean, instead of granting incentives, instead of granting subsidies, can the European Union induce the consumption of a specific production or energy?
I think it's a very nice question. Marta, do I have the authorization to sort of extend the session by 5 to 6 minutes?
Yes.
Okay, right. So I have an answer to this question, but I don't want to monopolize because I've been speaking more than the others. So if the others allow me to answer, then I do. Otherwise, if somebody has an answer, he would go first.
No, go ahead.
Go ahead, Eugen.
Okay, I think Joachim also has.
You are the chairman.
Yes, I am the chairman, but I think, you know, Joachim, your face, I've been knowing you for quite some time, you have something to say.
Okay, Pasquale, you know me well. I can see. Well, a very brief comment. I think it's been done actually. So as regards biofuels, we've moved away from granting tax incentives, and actually we have moved towards setting up requirements of minimum levels of biofuel in the fuel that you can buy at the petrol station. And the only real issue there was, as Pasquale has already mentioned, legal certainty, because a lot of producers had been relying on the tax incentives, and all of a sudden the entire system changed. That was an issue, but we made the effort, and I think it was successful. Right?
So I think, you know, from my perspective, my reaction, I try to be brief. We need to understand what we want. So if we want to have self-sufficiency, so we want to be independent from an energy perspective in Brazil, and if we can produce ethanol, then that is also something desirable, because at the end of the day, you still have energy at reasonable prices. And of course, you know, that is something that you can do. But I say, also in the European Union, we have problems from time to time with shortages of supply, just because, you know, one country is not paying the bill and then the pipelines are going through that country. So in a way, that is something which can to some extent be done. It could be done more. So it could be done more to the extent that the EU could intervene. But if we make the point that the energy policy has to go more towards the level, the supranational level, then it can be easier to intervene in this field. Now, I have Iñaki, Jerónimo, and Susanne, and I would like to try and fit them all, and my watch is 1:30 and 5 seconds, so please make your point. Yep.
Very brief. My reflection is, do we really need to solve problem of poor coordination between different policies with tax incentive, or we should review all the instruments we have, emission trading scheme, energy taxation, efficient energy directive, renewable energy directive. So that's my point. Are we solving a problem when we should face another one, who is review the existing instruments?
Yes, that's a kind of difficult question to answer. So it's a dilemma. Jerónimo.
Thank you very much, and thank you for great presentations. I do agree with, and I like quite a lot, two ideas mainly of the presentations. The first one is to reduce flexibility at national level. I think this is something that we have to manage to do. And the second one, I agree with the idea that the GBIR is in a way too generous. But what I'm asking is to problems with the solutions. The first one is moving to a case-by-case analysis in practically all situations might be excessive in a way. And I wonder whether it is possible to look for an intermediate solution, not moving to a case-by-case analysis, but thinking on changing the conditions of the GBIR so that there is room for still for a block exemption in certain cases, and in other cases you may need to impose other conditions different from the ones that are now applicable in the GBIR. Because case-by-case analysis, of course, has problems for companies and for operators in the market, legal certainty, which is extremely important here. And my second remark is with regard to the idea of selective and general measures. Because reducing flexibility at national level might also mean that you cannot reduce the concept of selectivity. If you reduce the concept of selectivity, then you are excluding the possibility of supervision by the European Commission, because it does not fall within the concept of state aid. So we have to pay attention to that, also to the concept of selectivity in this regard. But these were my 2 points. Thank you.
Mm-hmm. Thanks very much, Jerónimo. Susanne Åkerfeldt.
Thank you, Chairman. And first of all, I would also like to thank you very much for Marta and everyone else for allowing me to be here. And these are all subjects that are very close to my heart, so I will definitely looking forward to these discussions during these 2 days. And it was very interesting to hear the presentations, and I can't say I agree on all the issues presented, which is obviously the point. You shouldn't agree. First of all, I think there is one part of the discussion that we have been lacking this far, and that is when we talk about energy policy objectives and reaching, we don't talk about the transport sector. We have been talking a lot about the electricity sector, natural gas grids, and so on, but the biofuels, and is that really part of the solution, or is it part of the problem? When we see with the traffic sector, because our colleague from Brazil here talked about the ethanol, and I guess in your view and in our view, we see that as part of the solution rather. But the problem when you then link with state aid rules is that the state aid rules put more and more limitations on the possibilities for member states to have tax exemptions. And Alvaro started to touch upon the Swedish carbon tax, and we have significant problems there with the carbon tax because it's considered as a state aid by the Commission, and then we have to fulfill more and more limitations given by the state aid, and that is not really giving predictability to the trade, and that is really problematic. So it's a real problem, and no one would be happier than me if we could have more harmonization on the EU level. We tried for 3 years with the ETD and the revision of the Energy Tax Directive. Then the Commission felt obliged to take back that proposal because there was no way of going for unanimity. But we need well-functioning tools to reach our different tools. There are different tools in the toolbox, and we do need them. And in my view, the CO2 tax, a proper designed carbon tax, is really such an excellent tool. But the state aid rules is putting severe limitations on that. And I wouldn't agree with what Mr. Casoria said first, that you actually, if you've just fulfilled the minimum level, then you're okay, because that's not true. The Commission does not accept biofuels reductions to be covered by Section 3.7. Instead, you need to go by the renewable section, and that is, then we are back into this discussion about food-based and so on. So these were a couple of fires I wanted to put into the debate, and definitely more discussions about this difficult but very interesting subject. Thank you.
Thank you very much, Susanne. And I think, it's also, we should also take the opportunity to understand that all sessions are pretty much related. So even if I have to try and protect lunch, and so that couldn't perhaps make me in the interest of all that we don't reply immediately to this point. Indeed, the point of transport and biofuel has not been addressed, but that can also be an opportunity if the chair of the following session, one of which is Peach and Slot and the other one is yourself, Susanne, allow for it, then we can take also the possibility to keep those in the debate. As long as we manage to be disciplined with our presentation, then it's nice that we have the opportunity of a little bit of debate. But time has come to say thanks very much to our speakers, Iñaki, Luis, and Joachim, and thank also for you to listen to us, and we'll be back in 1 hour.